22 reasons to get your estate plan in place in 2022. What's the first reason? The healthcare crisis. So I don't want to spend a whole lot of time talking about the current situation we're in, but we all have to acknowledge the reality that healthcare has never been such a big concern to all of us. And it really highlights one of the reasons that you should have your estate plan in place. So number one is because of the healthcare situation that many of us are experiencing, there needs to be an estate planning document that is called a healthcare power of attorney. What that document is where you authorize someone whom you trust to speak on your behalf in case you can't do it yourself. That person is called your healthcare agent. Sometimes people will think of it as a power of attorney. It's the same thing. It's who you have authorized to speak for you if you can't speak for yourself because of some sort of healthcare situation. So that's your healthcare power of attorney. And what that will do is that will ensure that there is no confusion. If something should happen to you, you need medical treatment, and you're not able to communicate your wishes to the healthcare provider, well, there is somebody who will be, and that's the person you have designated. This is especially important if you are in a situation where, for example, you live with somebody, they're the person you want to speak on your behalf, but let's say you're not married to them, even though they might be your life partner. You know, a person who you're not married to has no legal authority to speak on your behalf unless you say you want them to through that durable power of attorney. So that is probably one of the number one reasons in 2022 to get your estate plan in order. Question is, does it need to be durable? Really good question. Absolutely. Durable means that the document is still effective even if you have lost capacity. What that means is that you can't, losing capacity, it has a wide range. Is it just for a moment or is it for a long period of time? Well, if you are unconscious, you have no capabilities of doing anything. So the reason that the healthcare power of attorney must be durable is that it continues in effect. It is not revoked by your inability to communicate for yourself. So absolutely, it must be durable. Really good question. So number two, and if you think of questions after we've moved on, please ask them anyway. So we'll come back to it. I think that it's really helpful when people do pose questions because, I'm an estate planning lawyer. I do this all the time. I talk to clients all the time about this. And sometimes it's really helpful if a non-attorney actually raises their hand, asks a question, because you'll be asking a really good question that somebody else might have on their mind that I'm not even thinking about. So please ask those questions. All right, number two, authorize your healthcare agent. So this kind of fits with what we were just talking about. What does the healthcare power of attorney do? It gives authority to your healthcare agent. It includes information such as what's called a HIPAA release. This is the ability for your healthcare provider to give information about your personal situation, about your healthcare situation. So there is authority for the physician to speak to your healthcare agent, which is something, whenever you go to the doctor, you fill out a new HIPAA privacy form. The healthcare power of attorney will give authority to not just your healthcare agent to speak on your behalf, but also for it to be reciprocal, that the healthcare provider can provide information. You think, well, of course they have to be able to do that. Well, common sense and actually what the legalities aren't necessarily the same all the time. So making sure that there is somebody who is authorized to speak on your behalf and receive information on your behalf is critically important if you are ever facing any kind of a healthcare situation. So make sure you've protected yourself, you've designated who you want to speak on your behalf, and they are authorized to speak on your behalf, and they are authorized to receive information. This is really interesting. Somebody has assets out of this country in Ireland. Do you need to have a separate will in Ireland for these assets? I'm going to hold on that until we get to talking about the will, but I will make a note and come back to that. All right, number 3, living will. Now, I just said I was going to come back to talking and answering the question about the will and do you need a separate will when you're in Ireland? And then I just said, number 3, living will. This is really confusing. I don't know who came up with the idea that calling a healthcare directive or an advance directive a living will made any sense. So a living will, as the terminology is used, means your healthcare directive, which is also called an advance directive. A living will has absolutely nothing to do with your last will and testament, and therefore it is very confusing. Nonetheless, number 3, living will, advance directive, healthcare directive, that is also something that's very important for everyone to have. What does it do? What does it say? How is it different than your healthcare agent? Well, your healthcare agent is the person that speaks for you on your behalf. They're authorized under your healthcare durable power of attorney. But your advance directive, your healthcare directive, your living will, those are your end of life wishes. So what does that mean? Probably everybody has heard the term pull the plug. What that is that when you are at end of life, if you don't want to be kept alive artificially through, machines, through artificial feeding, etc., when at that point in time, when your doctors have put in your medical record, you know what, everything beyond this is futile in terms of the person will not recover based on all medical probability, that we can keep this body alive, but that doesn't mean that this person will ever come back to be the person who they were before or have any quality of life. Most people at that situation, everybody's different, but most people say, you know what, if I'm at that point where machines can keep me going, but there's no hope of me ever becoming who I am or was, pull a plug. That's called a healthcare directive. Now, as I said, your wishes could be, no, I want every single thing done for the rest of however long it takes for years and years and years, keep me hooked up to machinery. If that's your wishes, please put it in your healthcare directive, because you can bet your healthcare agent who's going to be advocating on your behalf, stating your wishes, is going to encounter a lot of resistance from the medical facility, who won't want to keep you going on and on and on forever for their own reasons. So whether you say keep me going at all costs or let me go, let me die peacefully, I'm okay with that. Put it in writing. How you put it in writing is through your healthcare directive. Of the 22 reasons to get your estate plan in 2022, I think one of the biggest reasons is what I call communication. Number 4, communication. Do not assume that everybody knows what your wishes are. We just talked about your healthcare directive and your end of life wishes. I recommend that it be in writing, because if it's in writing, it's clear that you've communicated no heroic measures. But even when you have your durable power of attorney for healthcare and your healthcare directive, and you've signed off on it and you've nominated the person, they've agreed to serve, this is where communications comes in. Have you talked to that person? You can't just assume that they want to be your healthcare agent, and you can't just assume that they know what you want. You can name somebody, but they have no obligation to serve, no legal obligation, maybe moral, but no legal obligation. So they might not want to be your healthcare agent. It might be too much for them. They might be dealing with their own things in life and they just can't handle it. So part of it in your estate plan in order includes communicating with people who's going to be your healthcare agent. Are they willing to serve? And what are your wishes? Talk with them about what your wishes are, because at end of life, it might be black and white, or it might be different shades of, well, what is the situation? You might want to say to them, if the doctors say there's no hope, advocate for me for the next 24, 48 hours, because I believe that might make a difference. And I might be able to come back to a sense, to, a better quality of life, even if the doctors say no, she won't. How will your healthcare agent know if you don't have a conversation? So it's a conversation about what your wishes are, but what estate planning involves, it involves, your family, your loved ones. It's not a one-way street. Oftentimes, and we encourage clients when they're talking about what their wishes are, that what they also do is find out what their family members' wishes are. Talk with them, get a conversation going about what is it that you would want, because they may or may not have all their estate plan in place, their ducks in a row, and you may still be called upon to help them or speak for them, because in medicine, there's a hierarchy in terms of who has authority. The person who has authority is the healthcare agent. Well, they don't have a healthcare power of attorney, and there's no healthcare agent designated legally under the documents. Nonetheless, the medical providers are going to turn to the spouse. If there's no spouse, to the kids. If there's 5 kids, it's not the eldest, it's like a committee of kids. So having communication will make things easier. Hopefully you'll have the right estate planning documents in place, but if you communicate with your loved ones about what your wishes are, you might find out what their wishes are as well, and that might make a difference if that situation were ever to come up. The thing is about communication, if you do it while you're alive and well and not under some sort of stress or, duress, it makes things a lot easier. Just think about how you can communicate when you're a good mind versus how you would communicate if everything is going bad and it's a crisis. So it's really important to communicate and get your estate planning in place when there is not a crisis. I mean, we do crisis planning all the time. It's just not the best experience for anybody, especially the clients when they're facing a crisis. Number 5, let's move off the healthcare discussion and move to your finances. Part of estate planning is making sure that you have in place financial safeguards. So what does that mean? Well, when you are alive, and if you have been in an accident or you're at the hospital and maybe you're there for a long period of time, not just a short period of time, you're going to need what's called a general durable power of attorney for finances. So it works very similar as we talked about with a durable power of attorney for healthcare, but it's for finances. And so through that document, durable, because you've lost capacity, and so you need it to be durable, somebody will be able to manage all your financial affairs, pay your bills, do whatever, file your taxes. Maybe your house needs to be sold. Maybe you need to apply for government benefits. There's all sorts of maybes that if you have a general durable power of attorney for finances in place, your finances will be far more safeguarded than if you don't. Which leads me to number 6, which is avoid the court if you can. Avoid guardianships and conservatorships, which is now in 2022 what the Washington courts call, what used to be called a financial guardianship is now called a conservatorship. They mean the same thing. But nationwide, you often hear the term conservatorship used when they're talking about financial guardian protections. When does somebody need the court to intervene and protect themselves, protect their finances? When that comes into play is when somebody has lost capacity and they do not have the durable power of attorney for finances. When does that happen? That happens just naturally because people don't think that they are ever going to lose capacity. Nobody wants to lose capacity, and they don't think it's ever going to happen to them. They think it's going to happen to somebody else. They think it's going to happen to the next generation up, maybe seeing Alzheimer's or some cognitive decline, or somebody who has had a stroke. But really, human nature, very understandable. Nobody thinks it's going to happen to them. As an estate planning attorney, what I see all the time is that it happens to people all the time. So having an estate plan in place is going to make sure that you and your finances don't have to be in the court system subject to a court-ordered guardianship or conservatorship. One of the things I do want to mention, and this is really a very common misconception, is people think, well, I'm married, so if my spouse loses capacity, I can manage his affairs. No, I can't. If our names are both on the title to our home, yes, we both own them. But if I need to sell the house, I can't sell it because I cannot sign his name on the sale and do a new deed if I don't have a durable power of attorney and he's lost capacity. So being married doesn't fix this problem. If he doesn't have a durable power of attorney and he loses capacity, he's subject to court-ordered guardianship, and I have to deal with the courts as his spouse. I have to do a personal care plan. I have to do a financial plan. I have to disclose to the court everything about our finances. We're Washington community property. We're married, so everything that's personal to me is also in the court. This is really an eye-opener to people when it happens to them, and it's a really terrible situation. Easy to avoid by getting a general durable power of attorney, not just for yourself, but for your spouse as well. Number 7, it fits right with avoiding the courts. Avoid probate. Probably everybody has heard that probate should be avoided. Now, we're going to talk about in a little while, well, maybe probate should not be avoided. But in some situations, yes, probate should be avoided. If there's no benefit to it, avoid probate. There's many ways that on somebody's death, probate can be avoided. One of the main ways to avoid probate is through a revocable living trust. Now, a revocable living trust is a tool, a legal document that you sign while you're alive, and its primary purpose, I would say, is to avoid probate when you die. With a revocable living trust, if it's done right, that means if you fund the trust, if you manage the trust, if when you sell a house, you put your new house into the trust, if your bank accounts are retitled in the trust, if all of your assets have to be titled in the trust that can be titled in the trust. And if you do it right, then when you die, your assets go wherever you want them to go without the need for a probate. Probate is where a will is filed with the court issues letters testamentary to the executor, they go on their way and they administer your estate. Well, a lot of people want to avoid probate. In certain states, definitely you want to avoid probate, California, for example. But in Washington, probates are not like in California, they're not like in Oregon, they're called non-intervention. They can be fairly simple, but nonetheless, probate will involve legal fees unless you try to do it yourself. If you do that, I can pretty much tell you, you're probably not going to do it correctly. So avoid probate if there is no benefit for probate. How do you do that? One of the ways you can do it is through a revocable living trust. That might be a great estate planning tool for you. Whether it is or not, I can't tell you, because you need to talk to your lawyer to say, hey, is this a good estate planning tool for me or not? Number 8, protect your assets when you are gone. How do you do that? Can you do that through a revocable living trust? Not for your spouse, you can't. Maybe for your kids, but not for your spouse. So I'm the founder of Elder Law Group. We know government benefits. We know long-term care costs. We work with all generations, but the people who are particularly concerned about protecting their assets for their spouse, especially, are usually retirees. Why are they so concerned? Because of long-term care costs, because we all know long-term care is expensive. It's not $5,000 a month typically. It's at least between $5,000 and $10,000, if not $10,000 to $15,000. I said per month. So it doesn't take a whole lot of time that somebody is in long-term care that you can see the assets deplete and then they're gone. How do you make sure that that doesn't happen? How do you make sure that you leave money for your spouse and you leave money for your spouse, even if they're in long-term care, and still have the state pay for their care? There is a way to do that. How do you do it? You need a will with asset protection and asset protection trust. It's also called a supplemental needs trust. And you need a probate. Didn't I just say avoid probate? I said avoid probate if there is no benefit. But if there is a benefit, then probate might be the smartest thing for you to do. Let me give you an example. Let's say you have a couple and the first spouse dies and they want to make sure that their surviving spouse, let's say the husband dies, surviving spouse has Alzheimer's. She's going to need care. Let's say this couple has $800,000 in total assets. Well, if they did a revocable living trust, or if they didn't see an elder law attorney, they are going to end up with a plan where all of that $800,000 is going to be spent down before the surviving spouse with Alzheimer's is going to get state benefits to pay for her care. Contrast that to, you go to an elder law attorney, they do a will for the husband and the wife. The husband dies, the will has an asset protection trust in it. After he has died, his share of this $800,000 estate or $400,000 is going to pay to an asset protection supplemental needs trust for the surviving spouse. $400,000, half of his estate. Yes, his wife is going to need care, and she likely will spend down her money unless there's a Medicaid strategy in between, but let's put that aside for now. I really don't want to complicate it too much. Let's say that she spends down her $400,000. Okay. Does she need to spend down the $400,000 that is in this trust that her husband left for her? No. She can have $400,000, whereas the person that doesn't have this plan can have only $2,000. That's it in countable assets. She can have $400,000. Why? Because it's not considered countable, because it's in the right kind of trust that the state honors. So through having a probate and having the right will with asset protection, that surviving spouse will have her care paid for by the state, yet have $400,000 in trust to make her care that much better, to supplement her needs, whatever. And then at the end of her life, it will go wherever they wanted it to go. So this couple's assets will never be depleted. They will never run out of money because they had this type of trust and they had a probate. That is one of the main tools that we have as an elder law firm to protect assets and ensure that you will leave your spouse money and they will never become impoverished. Number 9. I'm going to go back to the Ireland question now, because we were just talking about wills. Do I need a separate will in Ireland for these assets? I don't know the answer to that. I am licensed in Idaho and Washington. And when it comes to the laws of other jurisdictions, and if we have clients in Ireland, my advice to you would be see a lawyer in Ireland, because they will have the answer to that. Maybe there is an attorney who is licensed in Ireland and in Washington. That might be possible. I don't know if such a person exists. If they do, they would be perfect to answer your question. If there is no such person, you're really going to need to seek out legal advice in Ireland. And that's true, be it Ireland or any other state, or I mean, any other country. So I know what I know. And when I don't know the answer, I am happy to tell you I don't know the answer to the question, but I would guide you by saying, seek an attorney in that jurisdiction. Question, are we going to discuss state level versus federal level powers of attorney? Great question. When I was talking earlier about powers of attorney, durable powers of attorney, those are state level, which means they would be honored in the state of Washington and any other state of the union based on the Equal Protection Clause of the Constitution. Now, you might need a lawyer to help get the Washington power of attorney honored in Arizona or New York or somewhere else, but it will be enforceable. However, federally, the Veterans Administration, they don't recognize state powers of attorney. Social Security, they don't either. They have their own system where they want someone to be appointed as a representative payee to manage somebody's Social Security benefits. So I'm so glad this question was brought up, because it is frustrating, because just having listened to me talk about powers of attorney and how you need them doesn't go far enough. Because if you're dealing with any federal agency, Social Security or VA, they have their own set of rules. And they will want you to follow their sets of rules and become a representative power of attorney, representative payee is what they call it, or the VA has their own system. So really good question, which leads me to give you one more comment. If you do have a general durable power of attorney for finances, I tell clients, take it to your financial institutions, show it to them. They will look at it and they'll either say, oh, that's great, let's keep a copy on file, or they say, oh, well, that's really interesting. Would you sign our own form power of attorney? Because our bank, our financial institution likes to see our own form. I tell clients, go ahead and sign that. But what you've done by presenting it and doing this forward planning is you've made sure that the person that you want to be your voice, your power of attorney, will not have problems when it goes to transacting business on your behalf. Really good questions. When we're talking about wills, we want you to, number 9, appoint the right executor. I could tell you so many stories of what goes wrong when you appoint the wrong person. It is a mess. It does not have to be your eldest son. Believe me, that could be the wrong person. You want to appoint the person who is business oriented, can get stuff done, pretty much is no nonsense, and you can rely upon them. They can make decisions. Or if they don't know what they're doing completely, they will seek out help. They will work with a law firm. We guide people through the process. Where you really run into problems is when the personal representative doesn't want to listen to the law firm. They don't see the value of what's going on. They don't do their job. It goes on for 2 years. And it ends up being not what you would have wanted, which is a simple administration of your estate that's done pretty easily. You appoint the wrong person, that is not going to be the outcome. So give some thought to who the right executor is. Really important. Number 9, appoint the right executor of your will. Which kind of leads to number 10, which is avoid disputes. If you have a good estate plan in place, there's very little room for people to argue or dispute. And even if they do, because they're still acting like they're in the sandbox, and they go to a lawyer, the lawyer's going to say, what do you want me to do? Everything is laid out. You don't have any basis for complaint. So, you still might have people who are unhappy and they want to raise a dispute, but there's nowhere for them to go. So part of doing estate planning is, and a lot of times clients want us to include certain language, and we might say, that's probably not the best language to include in your will, because that might give somebody a basis for contesting your will. So we're not going to include that language. We'll include something else that conveys the same message. But by having a good estate plan, you are going to be avoiding disputes. Wills have no contest clauses in them. If you dispute it, you will inherit nothing. There's all sorts of things that lawyers do to help you avoid disputes. And if you remember back to number 9, appoint the right executor, that also goes a long way in avoiding disputes. You don't want an executor who is going to say, I know mom said everything equally to the 3 of us, but I really should get more. That's the wrong executor. And if you have a good estate plan, it's not going to allow anybody to do that, even if you appointed the wrong executor. That is really talking about estate planning, what happens when you die. Number 11 is, what if you have minor children and you and the other parent both pass away? That's a really hard scenario for anybody to even envision. Part of doing estate planning, it is really emotional in many ways, because you're helping clients go through and think about things that they don't want to think about. Nobody wants to think about they're not raising their minor kids. But it does happen, and you hear that it does happen. How do you make sure that your kids aren't going to, be tugged on by this grandparent and that grandparent, or this sibling or that sibling? Put in your will who you want to be their guardian. A will is where you will name a guardian for your minor children. And then the court will say, the parents wanted this person to be the guardian. That's what the will says. And unless there's some reason not to, the court will appoint that person as the guardian. So it really is something that is important for people to do if they have minor children. I know lots of times people who are younger think that they don't need an estate plan. If there is one reason they need an estate plan, so if you have grandchildren and your kids haven't done a will that has appointed who's going to be the guardian of your grandchildren, it might be a good idea to talk with them. I'll leave it at that. I have 2 grandchildren. All right. Number 12, avoid unintentional disinheritance. So again, we're talking about a will. What am I talking about? Unintentional disinheritance. What does that mean? I bet that there are people who are listening now who know what I'm talking about, though they might not know the term unintentional disinheritance. What that means is, and it happens with later in life marriages, is, let's say people have been married for 40 years and they have 2 kids together. This is probably the easiest way to explain it. And one of them dies, and they had wills that are outright, or that I call them I love you wills. When I die, everything goes to my husband, and then I'm sure he'll take care of our 2 kids, right? Later on down the road, who knows how much later, he remarries. And he and his new wife do an estate plan. And maybe that estate plan is same thing. I love you wills. Everything goes to the spouse. He dies. Now who has all the assets that he and I accrued over not only our marriage, but over our 40-year marriage? Now where are they? They're with this new wife who I've never met. My kids don't like. And my kids and his kids will never see any money, because it was all through simple wills that said, I love you, everything goes to you. I love you, everything goes to you. Nobody ever gave thought to, well, what happens on a remarriage? And they should have. So there are ways to protect your kids to make sure that at least your share of the assets, when I die, maybe my assets go to my husband. They go through some protective mechanism so that when he dies, they are going down to the 2 kids. So again, part of estate planning is thinking about things. Hey, I never thought about that before. Unintentional disinheritance happens, and you can prevent it from happening. That was number 12. Okay. Number 13, intentional disinheritance. Maybe you do not want all of your 3 kids to inherit. Maybe you want only 2 of your kids to inherit. And there's lots of reasons for that. It could be that the third child, has ample assets and they don't need any of your money, whereas the other 2 are at a stage in their lives where they would really benefit from your money. That's one reason you need to put it in a will, because if you don't have a will that says that, the laws of intestacy come into play. Laws of intestacy means that you don't have a will. Think of last will and testament. So intestacy means no will. So if you don't have a will, you're single, your assets are going to go to your 3 kids equally. If you don't want that to happen, have a will, and have a will say, I don't want somebody to inherit because they don't need the money, or I don't want somebody to inherit, and you know the reasons why. You don't want to put that in your will necessarily. You would simply say, I provide for these 2 children and not the third child, and you leave it at that, is what we generally advise. But if you want to disinherit somebody intentionally, you must have an estate plan, a will that says that. If you're using a revocable living trust platform, your revocable living trust also must say that. We're talking about protecting your assets when you're gone. Number 14 is divorce. And in this case, what I'm talking about is divorce of your children. So you may love your daughter-in-law, your son-in-law. They are the best people in the world. We prepare estate plans for where you're at right now, but we also prepare estate plans for what may go wrong down the road. How do you protect your child's inheritance in case of a future later divorce? How you do that is you have the will provide that the child's inheritance is into a trust. There's all sorts of trusts we can use. One of the trusts that we use to protect against divorce is what we call a descendants trust. What that means is the divorcing spouse will never get any of that money. So divorce, protection of your child and their inheritance is reason number 14 to get your estate plan in place in 2022. Just to make sure everybody's on the same page here, we've gone through, I'm going to take just a real quick. Number 1 is because of the healthcare crisis. Second reason to get your estate plan in order in 2022 is authorize your healthcare agent to speak for you. Number 3 is living will. Number 4 is communication. Number 5 are financial safeguards, talking about durable powers of attorney. Number 6 is to avoid the court, guardianships and conservatorships. Number 7, avoid probate. Number 8, protect your assets. Number 9, appoint the right executor. Number 10, avoid disputes. Number 11, name a guardian for minor children through a will. Number 12, avoid unintentional disinheritance. And number 13, intentionally disinherit. Number 14 is divorce. And by the way, all of this and this checklist you will be getting. For all of those who have registered, we will be sending you an email with this information. We're not done yet, but I just want you to know that that will be coming your way via email. Let's move on to number 15, protect your grandchildren. I think I mentioned I have a couple grandchildren. They're very dear to me. I have never met a client who hasn't told me the same thing. Their grandchildren are very dear to them too. You can provide for your grandchildren in your will or through your trust, and you can protect assets for them from all sorts of threats. From if they're too young, there's going to be a trustee of the trust until they reach the age where they can manage it themselves, if they ever can. We can have trust continue on for their lifetime as well. For whatever reason may be a good reason to continue the trust. But do keep in mind that you can provide for your grandchildren and in a way that benefits them and doesn't create problems for them. Sometimes giving people money without protections, without a trust, without protective mechanisms is a really bad idea. There could be lifestyle issues. There could be all sorts of reasons why you don't want to give somebody who is 18 years old $200,000 in a lump sum, for example. Number 16, provide for your spouse. So far, we've talked about, estate planning documents that are really good ideas to protect you and your spouse, the durable powers of attorney, the wills with asset protection trusts. So 16 really is talking about providing for your spouse for their lifetime, no matter what their situation is. Maybe they're facing long-term care costs. We want to have that asset protection supplemental needs trust. Maybe you're in a taxable situation. You want to make sure that they don't pay any taxes. So we might have your assets go to a bypass credit shelter trust. When I say trust, just when anybody ever says the word trust, keep in mind that the next question you should ask is what kind of a trust? Because trust encompasses so many different planning tools. So most people we meet with, one of their main concerns is making sure that they've taken care of their spouse when they're gone. That gives them a lot of comfort. There are different ways to provide for your spouse. A will is one of the best ways that you can make sure that your spouse will be provided for, assets will be protected. They'll be protected from creditors, from maybe bad spending that can happen. As people age, they're much more susceptible to financial exploitation. There's a lot of ways that we can protect people from whatever risks that they may face later in life. Number 17, special assets. Now, for a lot of people, their personal property collections are really important to them. For a lot of people, it may be guns. For a lot of people, it may be their jewelry, their artwork. When you have an estate plan prepared for you, your will include something that's called a personal property list. It is a list that you can say, I want my classic 64 Corvette to go to my son. I want my whatever to go to whomever you want it to go. And that's a list that you prepare. This is like the only estate planning document we tell our clients. It's okay for you to write down the name, write down the item. And if you change your mind, go ahead and tear up that list and do a new list. This is a way that you can make sure, without all the formalities and encumbrances of a will, and it's much more efficient if you just do your own list. Now, is that list enforceable absent a will? No, it has to be part of the estate plan and the will process. So you'll want to make sure that you have an estate plan in place. But what I'm trying to convey is that one of the reasons to make sure you have an estate plan is to make sure that you know that those special items that mean a lot to you will go to the people who will really appreciate them. 18, charities. Not everybody wants all their assets to go to their kids, to their relatives, to family members, to friends. For many people, they want charities that they have. Charitable giving has been a part of their whole life, or if not, they want to make sure that their money does good when they are gone. Having charities designated either through your will or through beneficiary designations of other accounts, and we haven't spent any time talking about beneficiary designations. That is a really important part of anybody's estate plan. Having charities that are really near and dear to your heart, that is a way to make an impact when you're gone. And giving to charities, qualified charities, has a very positive tax benefit. So when people are looking at, they have a taxable estate, which, by the way, in Washington this year, 2022, it's $2.193 million per person. Federally, it's $12.06 million per person. So that's what the tax levels are. Other states have no state tax, like Idaho, for example. Other states like Oregon have a very low estate tax. I believe it's $1 million. But the point is that not only can you make an impact with your charity, you can actually have the benefit of avoiding estate taxes by having charities be a part of your estate plan. 19, pets. speaking of what's near and dear to your heart, for many of us, we know that our pets, Fido, Kitty, Polly the parrot, or Freddie the ferret, whatever, everybody has their own, pets that are particularly precious to them. For many people, they just make sure that they've talked to family members. And if you have a really good pet, there's going to be people that are willing to take your pet. But for some people, they really want the formality of a pet trust. So you can create a pet trust. We have a statute in Washington that says that recognizes pet trusts. Pets are considered personal property, by the way, but there is a way that you can create a pet trust through your will. You're going to name who the guardian is of your pet. You're going to allocate a certain amount of money, and there'll be a trustee of your pet trust, and that may or may not be the same person as the person who is the guardian or takes care of your pet. We'll talk about what is reasonable to, fund this trust with. And if your estate plan is set up for a probate, it's just part of the probate. If your estate plan is not set up for a probate, then pet trust might not be the way you want to go, because rare is a person who wants to do a probate just to set up the pet trust, but it's an option. And it allows you to make sure that your beloved pet is going to be cared for by somebody you trust, that they are going to know what to do, who the vet is, there's going to be money, and your pet is going to be well cared for after you're gone. Number 20, special needs. When people hear the term elder law, they think that is attorneys for old people. That is not the case. Elder law encompasses estate planning for people, for anyone, but especially what we have knowledge about as elder law attorneys are government benefits. Special needs, if you have a special needs child, you know what I am talking about. That child of yours, be it a minor or an adult, may never be able to stand on their own 2 feet, earn a living, take care of themselves, be able to live independently. So part of what we do as elder law attorneys with estate planning is make sure that your special needs loved one has the right protections in place for them through your estate plan. Typically, that will be a trust that is put in your will. And that trust serves to be the recipient of the child's inheritance, special needs inheritance, but will not interfere with their eligibility for government needs-based benefits. That could be SSI and that could be Medicaid. Those are really important benefits that they get because of their special needs and their disability. So if you have a special needs child, a special needs loved one, you'll want to see an elder law attorney, not a traditional estate planning lawyer, but an elder law attorney, because we have that expertise with how to ensure that benefits will still be forthcoming, paid for by the government to your loved one, your special needs loved one, but they'll have this extra money set aside that won't interfere with those benefits. And the money in that trust will provide, supplemental funds to make their lives that much better. So that was number 20. 21, we're coming to the end, and I will answer questions as well. Business planning. If you have a business, part of having a business is making sure that it will continue when you're gone. Business succession planning. So if you have a business and you want to make sure that on your death it will continue, or somebody else will be able to run it, or at least it will have value, such that a business succession expert will be able to sell your business because it has value, then business succession planning should be a part of your estate plan. Number 22, and nobody is going to be surprised by this one. By putting your affairs in order, you have done the heavy lifting to make sure that when you are gone, or if you're here and you're disabled or incapacitated, that you haven't left a mess for those who you've left behind. It really is a gift that you give to your loved ones, to those you care about. But as much or more than that, it really allows you to take a deep breath, the weight is off your shoulders. You have that peace of mind knowing that you did what had to be done or what should be done to leave things in the best way you possibly could. Your affairs are in order. You've got that peace of mind. So really, out of everything, just having that weight off your shoulders, knowing that it's been taken care of, you don't have to worry about it anymore. Number 22, peace of mind, I think, is probably the most important reason to get your affairs in order, your estate plan in place in 2022. As I said earlier, we're going to be sending you this 22 in 2022 checklist, and we will also be sending you with a certificate for a complimentary consultation, which you can use if you choose. If you qualify, then we would be pleased to meet with you and answer your questions and do that on a complimentary basis. Typically, if there is a charge for an estate plan or estate planning consultation, if you qualify, there will be no charge for that consultation. To get in touch with us, call us at 509-468-0551. Go to our website, which is elgwa.com. And I'm going to continue, but I just want to make sure that for those who want to sign off, feel free to do so. When you get the checklist or when you get the consultation certificate, reach out to us by telephone, reach out to us by going to our website. That information is in the chat box. I am going to scroll back up on the chat box though, and I'm going to see if there's any questions that I haven't got to yet. So somebody asked a question about a half hour ago. Thank you for your patience, about asset protection for a single woman with one adult child. The question I need to answer in two ways. Are you talking about protecting assets for yourself in case you need long-term care? That is something that we do as a part of what's called Medicaid asset preservation strategies. I think we should do a whole nother talk about that. So we're going to make a note about that. If you're protecting assets for your adult child when you are gone, that can be done through any of the trusts that we talked about. An asset protection trust for your child, a descendants trust to protect against divorcing spouses. So there are ways to protect. If you have an adult child, you're a single person, yes, we can help you with that as well. How do you remunerate agents, executors, healthcare representatives, guardians, financial power of attorney, etc.? I think it's really important to make sure that the legal documents say that whomever is serving on your behalf is entitled to be paid for their services. So our powers of attorney, our wills, everything says that they're entitled to be paid. Now, how much should they be paid? Well, that depends on what they are doing and what their qualifications are. So somebody who is a CPA that you appoint as your financial power of attorney might be deserving of a higher rate than somebody who is not of that high level of qualification. So how much they should be paid depends really upon what they're doing and what their qualifications are. Having said that, we actually put in our healthcare power of attorney that the healthcare agent should be paid at a rate that if they were a professional, if they were a geriatric care manager, and they charge about $100 an hour for a geriatric care manager. We give a range of about $80 to $120 an hour. Your healthcare agent can receive that money from your estate. Now, do people do that? Generally not, no. And usually it's a family member, so they're not going to do that. But let's say there's a good reason for them to be collecting that money. Maybe it's part of a Medicaid strategy that is going to be implemented. So we want to transfer money from the ill person to the healthcare agent. That's a good vehicle for doing that. When it comes to executors or personal representatives, again, it's kind of like financial POAs, depends on what their qualifications are. In Spokane County, there will be no problem for an executor asking for between $20 to $50 an hour. That's a standard range that's well accepted. Let's say they're a higher qualified person. Can they get $75 to $100 an hour? Maybe, depending on what they're doing, depending on the services they're providing. But if they're charging $100 an hour to clean out the pantry, no, they should have delegated that to a service who would have done it for $25 to $50 an hour. But I do believe it's important that the people who are working on your behalf know that they can get paid. If they do get paid, they have to report it as income to the IRS, though. Next question. Executor for the husband's will. Oh, he died in October. I am so sorry for that. That really makes real what we're talking about. Please reach out, contact us. We would be happy to give you guidance to tell you, well, is there going to be a probate or there won't be a need for a probate? We definitely want to help you. So please reach out to us, 509-468-0551. I said it a couple of times, but I'm repeating it just because I know sometimes I don't get the number on the first time. But if anybody has questions, if this has raised anything in your mind, we are happy to assist you. If you want us to help guide you to other resources, maybe you're out of state and you need help finding somebody, an attorney in another state, we would be happy to help you find that other attorney. And we really want to be able to be a resource for you. Somebody asked if somebody here at ELG Estate Planning can be an executor. We really don't do that. There's an inherent conflict of interest. We could do it and we could do it really well, but we prefer to really stick very closely to the bar ethics rules. And just from our perspective, our practice, we would prefer that you have named somebody who is a professional fiduciary executor. We'll help you, give you guidance as to who that person might be if you don't want to appoint a family member, which is understandable. There's often times where people say they want a professional. We'll help give you guidance on that. So please reach out to us and we'll give you guidance, but we don't prefer to serve as an executor, no. As in the chat, we actually have a YouTube channel. Maybe you're watching this on YouTube. It's not the live webinar, but it's later. If you liked it, thank you so much for, listening, watching. If you'd like to give us a thumbs up or subscribe or share, we really do appreciate that as well. Ways to avoid financial exploitation. When money is put into a trust after somebody has died, those trusts are the way to avoid financial exploitation because the beneficiary may not be the trustee. Oftentimes they're not. When there hasn't been, so if it's during somebody's lifetime, that's much more difficult. We do have resources to help with that. But if what you're talking about is how do you avoid financial exploitation of somebody after death, typically the way to do that is through the creation of a trust. And if that trust was not created by the person's will, then what we need to look at is a different strategy, a different approach. So I would like to explore that further. So for those who want more information about that, please reach out to us. Yeah, before death, it's much more difficult, but there are strategies that we can talk about. They could be part of a Medicaid asset preservation strategy, or they could be part of involving other resources. By resources, I mean not necessarily care managers, but maybe there's other professional advisors who can help guide the family. And of course, there's other legal strategies as well. All right, we are now past the top of the hour. And so I'm going to, not seeing any more questions, I'm going to say thank you to everyone for attending. I've really enjoyed talking with you during this webinar, 22 Reasons in 2022 to get your estate plan in order. Thanks again.